Hi everyone, welcome to the Lawcast. My name is Melanie Thorley and I'm the director here. Now, I know I promised some HR stuff, but there's been so much going on in the world of crazy employment law cases. I just wanted to go over some of them. It's going to be a fairly short session today. We're going to have some fun with it. The first one is something that comes up actually all the time for me. As you know, employees and employers can sometimes be in a fair amount of conflict. There's there's lots of stuff going on, there's lots of untrust happening, and it's all fairly highly, all this charged energy, everyone's thinking everyone's out to get them, and it can be really, really grim environment. So what can happen is people can record. They might record with their phone in their pocket. They might just have their phone sitting there but secretly on record. Employers are doing it, employees are doing it. It's completely rife in the industry. Now, what to do with these recordings? Now, I am not going to provide any advice on whether or not it is lawful or not to record, but let's say you do. What's going on there? Well, the interesting thing about recording in the workplace is it can damage the employment relationship if you record. If you're an employee and you're recording without your employer's consent, it can irrevocably damage the relationship. And there are quite a few cases out there that state that if an employer catches an employee secretly recording, then that can be significant grounds for instant dismissal. Now, without diving into all the issues of unfair dismissal or general protections or what's happening there, I guess what you should be thinking if you're an employer is whether or not you wish for that meeting to be recorded. And either you should be recording it and saying it openly that you're recording and providing your employee with the opportunity or not to record. But yes, recordings are happening, and as an employer you might want to control that. As an employee, just be really careful. Setting aside the lawfulness of recording, whether it is or whether it isn't, and that changes depending on state you're in here in Australia, COVID recording that is, just really think about what might happen next with your employment if you are snapped with it. Let's say you do. Let's say there is a recording out there, it is done covertly, and now we're in court and the court has a chance to listen to it. Will the court listen to a covert recording? Well, the new case says yes, they will. And in fact, the case says that as long as we understand the provenance of that recording and that is legitimate, then there's no reason for the court not to consider it. Fascinating, absolutely fascinating. So I don't know what's going to happen next with that, everyone. But look, I think recording's really, really rife with all sorts of emotional charge. So I'm not saying do, I'm not saying don't, I'm just saying really stop and think about it first. But if it ends up in court, yeah, totally can be snapped and it can be used. So yeah, I think we all need to think about that. The next thing I want to talk about, and I've talked about this before, and this is these zombie agreements. Zombie agreements are agreements that sort of predate the Fair Work Act. They've got some mad clauses in them. They've got some very low employment situations and terms and conditions that sit well below what we call the national employment standards here in Australia. And they're old, which is why they're called zombie agreements, and they're alive, which is also why they're called zombie agreements. So these old alive agreements, which don't align with our fair work regime that we have here in Australia now, still apply. So the government when they did all their changes last year, they announced that they were going to put a sunset date on those zombie agreements, and that's going to be early December, like 6th of December or something like that. So that means that any zombie agreement that is in force today will no longer be in force then. It's going to die. The zombie gets his head chopped off, he gets burnt, that's it, it's gone. But is it? This mad situation has got these. There are 2 court cases, and the first one is about zombie agreements, and they're both about extending the zombie agreement. And the first one, there was an application by 2 senior employees asking to extend the zombie agreement by up to another 4 years, and can they do that? And the full bench said, no, these zombies need to die. They found no evidence that the employer would alter the employer's conditions of employment to their detriment. It would be reasonably simple for those conditions to be in the old zombie agreement to be reproduced in a contract of employment, and the employer's been senior and not lacking bargaining power, and so the current zombie agreement didn't reflect the employee's circumstances and was substantially obsolete. Of course it is. It's more than 13 years old. It's probably older. And the application simply sought to maximise the period of extension, so they were dismissed. Seems fair, right? Doesn't change anything about their employment. The employer wasn't going to alter their conditions at all. They were going to reduce into a contract this stuff in the enterprise agreement that was about to die. That all seems pretty simple and seems like a good idea. But in the other case, they wanted a 12-month extension of the zombie agreement to allow for new bargaining. They said yes to that. So, I mean, I haven't read both cases and I don't know all the backgrounds, but it is kind of weird that you've got in one circumstance a situation saying, well, no, you can't extend it. You can reduce the stuff into writing, you can stuff it into a contract, you can agree to this stuff, but no extension. And on this one, it's, yeah, let's extend. I mean, slightly different situations. We've got a zombie agreement wanting to be extended by 12 months versus 4 years. It's to allow for new bargaining versus we just want the old agreement to put in place. But honestly, guys, we've had this. We've known that we're going to have these zombie agreements by the time they die for more than a year. I say, get a wiggle on. Anyway, now for the mad cases. Now, those of you who are regular listeners will constantly hear me say from time to time that why are people filing unfair dismissals when they're doing such crazy stuff? We've got a couple of cases here, both of which have completely different outcomes, and one of them is still being decided and it's all a little bit funny. But we've got these 2 cases. One of them is with a train driver, and the union took it to an unfair dismissal, and then it went to appeal, and then that decision went to appeal, and now it's going to be heard again. So the answer hasn't happened yet. But this train driver had a massive bender the night before work. Massive bender. Apparently an aunt died, they were doing a wake, and it was a massive bender. He drove home, he was snapped for high range drinking, and then turned up to work the next morning to go to work. Didn't tell his boss that they had lost his license, but said it 3 days later. Now, a more suspicious person would say that the reason why he didn't say that he'd been drinking and got snapped for high range drinking the night before is because there's a possibility he could have presented over the limit in the morning, and he would have probably almost certainly been tested for alcohol. So he kind of got out of that one. A more cynical person would say that. I mean, there's no evidence in the case law or in the cases that show that he was drunk when driving that train the next morning. But needless to say, Sydney Trains was pretty upset with this. They argued that he should have told them his bender the night before if he had presented with a drink, had an alcohol rating the next day, and it would have been really damaging to the train company's reputation if that guy had driven a train while drunk, and he got terminated. Well, the union said no. What? Okay, the union has money and they can do that, but really, we've got a situation where this person is driving trains and not admitting that he got a high-range drink driving. I mean, I guess a more cynical person might say, how often did he do this and didn't get snapped and turned up to work the next morning without saying anything and didn't get tested? I don't know. I just kind of feel like my train drivers should be sober when they're driving trains. I honestly feel that way. And I can see the Sydney Train company's position on this point. And I'm always amazed that there are people out there who go, hell no, this is unfair. I should get my job back. Because what? Anyway, so in the first instance, I think it was Deputy President Cross, maybe not. Maybe in the first instance it wasn't Deputy President Cross. But anyway, in the first instance, the Fair Work Commission said, yeah, totally unfair, not related to work. You didn't know whether he was drunk or not, so unfair dismissal. And which I think is a crazy situation. But again, I haven't read the whole thing. There's a lot of cases here. There's 3 cases. And the train company took it to appeal. Go figure. They took it to appeal, and the appeal said, yeah, he totally should have been terminated. We're overturning it, and he's gone. And then the union took it to appeal, and the appeal of this one said, yeah, okay, there was a mistake made by the appeal commission, and we're going to have it considered again. I guess on this one, maybe the train driver was right in filing an unfair dismissal. Maybe it is a bit edgy, but from my perspective, I don't want my train drivers drunk. I don't want my truck drivers drinking. I don't want my truck drivers or train drivers on drugs. I want sobriety, people. And if there's a hint of that, I want the train drivers to come down heavy on these people. The train companies to come down heavy on these people. I don't want them to feel afraid to file, to give them show cause notices. I don't want that. I want them to be freely able to challenge these train and truck drivers. So it kind of worries me. Anyway, so that's that one. And the other mad case, which is completely insane as well. And this one this is a Virgin Australia sort of behind the scenes at the airport, baggage kind of moving around handler type guy. So he's not in the planes, he's out of the planes, he's zooming around. And he is, hands down, he's got himself in some trouble here. So this chap, Rimawee, he started making massive, he was fine for a while, for first few years of his employment, not a peep. And then all of a sudden something happened and he started complaining. He started complaining like crazy. He started complaining about all sorts of people doing all sorts of things. And every time it was investigated, it was found that either there was a mistake or it was misunderstood or it was blown out of control. Things like, there were a couple of ones that I read where everyone's wearing earmuffs. And they do hand signals, they shout, and I can't remember the third one. But that's how they all communicate. They communicate by hand signals, they communicate by shouting, and there's a few ways. So this one, he was somewhere and it was really noisy. They had the headphones on the whole time, and this guy, his supervisor apparently yelled at him to do something. Yeah, because that's... Rimawee said he shouldn't have yelled, he should have used hand signals. I found the yelling to be, really offensive. And this poor supervisor was like, I don't even remember the incident. I'm really sorry. We're yelling all the time. I'm sorry. I can't remember it. Anyway, it was put down to a misunderstanding. There was another one where Rimawee complained that someone had thrown a tea bag on the bottom of his little carty thing. And when questioned, the guy went, oh yeah, look, I was drinking my tea and the tea bag had popped open. There were tea leaves everywhere, and I went, Pah! And some of it got onto the guy's bonnet, and I went, oh look, sorry mate, and and this guy Rimawee had taken photos. There was no tea bag in the photos, and it was concluded that he got a bit of an overreaction. He was sending Facebook messages to females who asked him to stop. He was making complaint after complaint after complaint about stuff that just didn't seem to be happening. And then I don't know if it was a piece of resistance, but this is fascinating. Now, we hear sometimes of people saying that they're going to provide doctor certificates, and they do. And we hear sometimes that employers complain that these doctor certificates may not be genuine. And in this case, it's fascinating because somehow they got the doctor certificates from his doctor and doctor certificates presented by the employee, and they're different. They're not like crazy different, they're just different. Like this one says that Rimawee the doctor says that Rimawee suffers from adjustment disorder with mix and anxiety depression. He complains of multiple significant difficulties relating to recent incident of psychological trauma. Now, Rimawee's doctor's certificate that he gave to the Virgin said all that incident of psychological trauma at his workplace at Virgin Australia. Weird. The next one was, doctor said, this letters to confirm that Rimawee is fit for pre-injury duties. We close his insurance case. His medical condition is stable. He submitted one that said, this letters confirm that Rimawee is fit for pre-injury duties. His medical condition is stable. Not, we closed his insurance case. Kind of weird. Then we've got another one. Rimawee has a medical condition and will not be fit for work from date to date inclusive. This one is, dear Sir, Madam, Virgin Australia. He has a medical condition, won't be fit for work for date to date inclusive. He has complications after surgery that was done overseas. Apparently he went to the doctors and got a medical certificate that was never presented. And he's got a medical certificate that the medical practice doesn't have a record of. Rimawee has a medical condition and be unfit for work from date to date inclusive. His complications, which required lymphatic drainage procedure. Look, I think providing fake medical certificate or altered medical certificates and a fake medical certificate is grounds for termination enough. But there is a laundry list of stuff that this guy did, like laundry list of stuff. What surprises me, and again, going back to the original statements, is what was he doing filing an unfair dismissal? Hello? At what point do employees look at that and go, yeah, fair cop gov, took it for a ride, lasted a while. Why take this to hearing? It amazes me that the system is so broken that an employee that can be this destructive in the workplace is still allowed to progress a claim all the way through to a hearing. It amazes me. Absolutely amazes me. Because the employer has no choice but to take this through to a hearing. They don't get off the train. The applicant is in control of when the application is discontinued. Okay, set aside all the applications you can make and say that there's no warrant for prosecution. That never happens. And these poor employers, and in this one it's Virgin Australia, and people will go, oh, it's Virgin Australia, they've got the money, and they might have the money. But what if it's a small business? What if it's a business with 3 employees? And the case amounts to 30% of their income that year. How long do you think that company's going to be around for? There are some cases out there where, like in this one in particular, Remy was saying that he was going to resign but decided to stay to mess with Virgin. You just look at this and go, well, why is this guy allowed to file an unfair dismissal and progress it through to hearing? So, without ending on a doom note, I'm just really fascinated by this because we've had this regime now since 2009, so almost 24 years. We know that the employees who file these things have no real outcomes. There's very few reinstatements. The train driver wanted to be reinstated with back pay and continuity of employment. And that's a union case, and we can say that the unions overblow these things and whatever, and they have their own agenda. But again, we're talking about organisations here who are not just firing someone because they think it's funny. I don't understand now that we've had it for so long, why we still think that it's perfectly okay to have 12,000 applications a year. Why it's okay that we have these hearings and there's nutter-butters who are filing applications, pushing it all the way through and having no real chance of getting any success out of this. No, I'm not suggesting that either of these cases they were nutter-butters, but there are some crazy cases out there. There are some mad situations, and the Commission or the court has concluded that there's been no real case to be heard. But anyway, so in this one we've got zombie agreements, we've got mad situations in relation to train drivers, we've got someone who quite literally faked a doctor's certificate, and we've got recordings, which I think is fascinating. So as long as look, I think there's going to be a lot more going on there, but the case basically said, as long as you understand, as long as the court, we as a court can understand the providence, then there's no reason not to hear it. Fascinating. Fascinating when it comes to covert recordings. Anyway, thank you very much, everyone, for listening and watching again the podcast. Hopefully it wasn't too boring just looking at my face the whole time. New thing for me. I know it's a bit weird, but I've decided to stop dyeing my hair. Why does anyone care? Actually, no one should care. Absolutely no one should care. But I've decided that I'm successful. I don't care. My ego doesn't care whether other people see me as old or not. And quite frankly, I'm bloody sick of it. So over the next few months, you'll see, I assume because I am grey, a greyer and greyer Melanie. I'm really fascinated to see this happen, and I'm tired of conforming to what my view of society thinks of me, which is crazy because society's not thinking of me at all. So I'm just moving on from it, peoples. So it's more of a personal note. Anyway, everyone have a brilliant fortnight. I'll be back again in a couple of weeks. And look, this time, yes, I promise I will have something funny to say about HR. Thanks for watching.